Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. I am coming to you guys today with an update in the Sean Carter, well, actually, Jane Doe versus Sean Combs, all his entities, and Sean Carter. So, Alex Spiro has replied to the plaintiff's motion to proceed anonymously. If you guys remember, Buzbee filed a motion to continue to proceed as Jane Doe in this case, and Alex Spiro as well as Jay-Z was not having it. And they were saying that she's done did this and this, so Jay-Z should have an opportunity to know exactly who the accuser is. And so Busby has responded. So let's hop right on into it. So this was actually filed on yesterday. Let's see. All right. So it says consistent with the arguments raised in his motion to deny plaintiff's request to proceed anonymously, defendant Sean Carter respectfully submits the memorandum of law in opposition to plaintiff's motion to proceed anonymously. So here's their argument. And I'm on the fence about this because I have been doing some research and I have found that there are some cases in which the judge has denied the plaintiff to use the pseudonym. So we'll get into that after this. So it reads, for the reasons set forth in Mr. Carter's motion to deny plaintiff's request to proceed anonymously, the balance of interest at stake weighs strongly against granting plaintiff's motion to proceed under a pseudonym. The fundamental question is whether plaintiff has a substantial privacy interest that outweighs the customary and constitutionally embedded presumption of openness in judicial proceedings, and they cited sealed plaintiff versus sealed defendants. And in that particular case, it state well, pretty much it says she does not, meaning that uh she doesn't have substantial privacy where it would allow for them to proceed under a pseudonym. It goes on to say that plaintiff, who is an adult, has now decided to file an amended complaint through her counsel, has since admitted he did not vet it, in which she accuses Mr. Carter of engaging in heinous conduct more than 20 years ago. And we'll take a look at Exhibit 2 as well, which is the NBC article. And it says, and she has chosen to have her counsel loudly try this case in the media and the court of opinion. This is hilarious because remember when I told you guys about Alex Spiro, how the prosecution was on him for having to try a case in the public versus within the courts, the pot calling the kettle black. Indeed, 5 days after she filed the motion, plaintiff sat for an interview with NBC where she expressed that she is not afraid to advocate for herself, and in which she discussed personal details about herself, such as her status as a person with autism. Moreover, there is no evidence of exceptional circumstances that in and of themselves justify overriding the constitutional presumption of openness. Mr. Carter has a right to defend himself, including by investigating plaintiff, and the people have a right to know who is using their courts. And then they cited United States versus Pilcher, where it stated that that is especially true. Whereas here in that particular case, oh no, I'm sorry, they reference United States versus Pilcher. Hopefully, that's how you say that name. Then they state this is especially true where, as here, plaintiff interview with NBC made clear that there are blatant factual inconsistencies in her story, including who she spoke with, where the alleged conduct took place, and even how she got home, requiring plaintiff to admit that she has made some mistakes. For example, plaintiff claimed her father picked her up after the incident and drove her home. But when asked by NBC, plaintiff's father denied recalling ever picking his daughter up and driving her over 5 hours home to Rochester. But the identity of plaintiff's father, a crucial defense witness, is presently unknown to Mr. Carter due to plaintiff's use of a pseudonym. Plaintiff has not carried her burden to show that she is entitled to any exception remedy here. In conclusion, for these reasons, Mr. Carter respectfully requests that the court deny plaintiff's motion to proceed anonymously and require plaintiff to refile her complaint with her true name. I don't know how to feel about this, as I stated before, because there have been several of Diddy cases where the judge denied the pseudonym and they had to refile under their names. Now, I'm going to go over an article. Now, usually, normally, you don't ever use articles that are more than 7 years old, but I'm gonna go to it. Let me go to it. Replace this. So this is an article from it's a personal injury law blog. Kind of it falls under this arena. Um, Now it is in New York. The case is in New York, so I just felt that this would be appropriate because they do cite other cases similar to this situation. So, this article is New York judge rejects pseudonyms in essay cases. When Buzbee filed the motion to proceed anonymously, he did cite some cases where, in cases that were similar to this case, stating that the judge allowed them to go ahead and continue anonymously because of the nature of the case and the nature of the victim. So there are going to be some instances where that doesn't always happen. So this article reads, now this is troubling. In those cases I've brought where SA is a component, I have used Jane Doe's pseudonyms to protect the privacy of my clients. Now a federal judge says this can't be done in a case he has heard. In a decision on the front page of today's New York Journal by Judge Lynch, who is part of the Southern District of New York, mind you guys, this case is in the Southern District of New York. He denies the plaintiff the right to proceed in such fashion in Doe versus Del Rio. Quote, in this civil rights actions, plaintiffs Jane and John Doe seek damages from defendant police officers and the city of New York for allegedly egregious acts of police brutality and abuse. They have brought the suit pseudonymously with the permission of a judge of this court obtained ex parte before filing, contending that their interest in privacy outweighs the normal presumption that suits be brought in the parties' proper names. Defendant now moves to revoke this permission and require the caption to reflect the true names of the plaintiffs. And this is from the attorney speaking, after an extensive analysis of the pros and cons of allowing such actions, Judge Lynch goes on to write this, quote unquote, while there may be circumstances where the sensitivity of the subject matter is so great as itself to justify pseudonymity without a specific showing of harm, this case is not of such extreme sensitivity. Plaintiffs allege that the defendant Brady pulled plaintiff Jane Doe towards him and attacked her sexually by fondling her breast, arms, neck, and back, kissing her and rubbing his body again. The court is loath to weight degrees of violation and does not minimize the wrongfulness of the acts alleged or the suffering of anyone subjected to them. There is no such thing as a mere or minor forcible indignity. Nevertheless, there are degrees of abuse, and the actions alleged here are no more intimate than those alleged in hundreds of sexual harassment cases that are prosecuted openly in the games every day in our courts. The facts of this case are not sort of exceptional circumstances that in and of themselves justify overriding the constitutional presumption of openness. As Judge Lynch writes in a conclusion, I think is troubling considering the allegations. So, this is what Judge Lynch wrote. He said the court appreciates allegations and the complaint concerns events that anyone would prefer to keep private, and that there is evidence that Jane Doe has been psychologically harmed by those events. Nevertheless, the nature of the charged acts, repulsive as they are, is not so extreme as to support significantly an interest of anonymity. The court accepts that, as her therapist has attested, revisiting these events may occasion anxiety for Jane Doe. But the greater part of the distress occasioned by the lawsuit and intrinsic to the pursuit of this action, even under conditions of anonymity. Any additional burden resulting from the public revelations of plaintiff's identity has not been shown to be exceptional, and it must be borne in light of larger interests in open judicial proceedings. As plaintiffs have not established that this is an exceptional case warranting pseudonymous litigation, defendant's motion to require amendment of the caption of this case is granted. This is the conclusion by the federal judge. The attorney goes on to say that federal judges are powerful and wide discretion is given to their opinions, making a Second Circuit reversal unlikely. But it seems almost as if the individual has been victimized twice, first by the assailant, and then, if she chooses to use the courts, forcing her to reveal herself to the public at large. Judge Lynch has written that he does not want to or wish to minimize the wrongfulness of the acts alleged, but in forcing the plaintiff to reveal herself to the public, it seems he has done just that. What are you guys thinking about this? Um, in my honest, humblest opinion, I believe that the judge more than likely is going to require for this individual to file under their real name, to amend a complaint and file their name. As much as I don't want to think about that, I honestly think that he is going to, or not he, she, because I forgot this is Judge Torres. Judge Torres may require that they refile. Now I need to look to see if Judge Torres, if she has any, decisions that she has made in the past with SA suits and filing anonymously, to see if she's ever made any decisions on that and see how she ruled. Um, but just kind of based on everything, I don't know. And I did say I was going to take a look at the exhibits, but I don't even have the exhibits. Did I even pull? I don't even think I pulled them. But that's okay. Everybody knows about the NBC interview, so it's not really necessary to reread that. But y'all tell me what y'all think about this in the comments below. Do you think that Judge Torres will rule for Jane Doe to reveal herself? And do you think by her revealing herself, if that is something that she has to do, will that help Jay-Z's case out? Let me know what you think about that in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.